On this episode of Law Weekly, the Chief Justice of Nigeria, Justice Olukayode Ariwoola, speaks about the circumstances surrounding the leaked memo from the Supreme Court justices to the former CJN. We also have the highlights from the launch of the Compendium of Civil Rules and Regulations, the EFCC's workshop for journalists on reporting financial crimes, plus a recap of the top trending legal stories in the news. Hello and welcome to the program. I am Shola Shuyeli. The body of Senior Advocates of Nigeria, BOSAN, did an unusual thing recently. For the first time, they hosted a sitting Chief Justice of Nigeria. And the idea, amongst other things, was to put forward some of their concerns as it affects the judiciary, as well as to hear from the CJN how he hopes to address some of these concerns. So on Saturday, the 22nd of October, they hosted the CJN, Justice Olukayode Ariwoola, to a dinner in Lagos. The dinner, organized by the body of Senior Advocates of Nigeria, BOSAN, was attended by members of the executive, the legislature, and of course the judiciary. Not less than 80 senior advocates were also in attendance. It's an opportunity to celebrate Justice Olukayode Ariwoola on his appointment as substantive Chief Justice of Nigeria about 3 months after he was first sworn in an acting capacity. The CJN was also recently conferred with the National Award of the Grand Commander of the Order of the Niger, GCON. The Secretary of BOSAN, Senior Advocate of Nigeria, Olumide Shofowora, set the tone for the dinner with these opening remarks.
It was therefore the decision of the dinner subcommittee to host this reception in honor of our new Chief Justice of Nigeria, Mr. Justice Olukayode Ariwoola, GCON, as well as provide an opportunity for our body to present certain issues which have been agitating the minds of our members to a distinguished honoree, who is the head of the judiciary in this country, with a view to enhancing the administration of justice and observing the rule of law. Some of these issues are: 1, why has the Supreme Court not had its full complement of 22 justices, including the Chief Justice, as is provided for in the 1999 Constitution? There were some years in the recent past that the number of justices sitting at the court fell to as low as 13, without additional appointments being made for quite some time. 2, why have appointments to the Supreme Court bench excluded members of the body of Senior Advocates of Nigeria and even the academia, considering that some of the best justices that ever sat in the Supreme Court, for example, Honorable Justice Augustine Nnamani and Honorable Justice Teslim Olawale Elias, both of blessed memory, were from our body and the academia respectively. 3, we are also concerned about the conflicting decisions of the Supreme Court in recent years, which has made it difficult for the lower courts to observe the rule of law, the rule or principle of stare decisis.
The chairman of the event is the matriarch of the bar and first female senior advocate of Nigeria, Chief Folake Solanke. She is unavoidably absent and has sent her apologies and speech through the chairman of the body of benchers, Chief Wole Olanipekun, who goes on to read same to the gathering.
His Lordship has resumed office of the prestigious position as CJ during the turbulence now raging in the nation, even at the Supreme Court, when the justices had to write a letter to the former CJN, Honorable Justice Tanko Mohammed, concerning the disaffection within the Apex Court. Your Lordship was a signatory to that unprecedented letter, which was leaked to the media. Thus, your Lordship, with all due respect, knows about the causes of disaffection analyzing the letter. Suffice it mean to pray that God will empower and direct your Lordship to find solutions to the daunting problems. Dio volenti. It is clear that the problems which every one of us, both on the bench and at the bar, should now embark on is a crusade to restore the golden age of our learned profession. It is my humble opinion that if every one of us is corruption-free, then the whole profession will be corruption-free. Thus, everyone should engage in self-introspection, self-examination, self-analysis, and self-determination to exterminate the hydro-headed monster of corruption. All I can say now is that we must pray that your Lordship will succeed in leading the profession to engage in a crusade to restore the golden age of the profession, when judges and lawyers enjoyed highest respect of the populace. There is a need to establish trust and confidence in our learned profession. It is also my prayer that God will inspire and help the Honorable CJN to restore honor, dignity, and integrity in our legal system.
For some time now, there's been complaints as regards the independence of the judiciary, and the body of senior advocates took the opportunity to bear their minds on this issue.
It's very unfortunate, my lord, that the Supreme Court lost a major opportunity when a case was presented before it about how the judiciary should assert its own independence in an extremely, with all due respect, extremely poor decision. The Supreme Court lost the opportunity to set out the parameters for its funding. So I hope that this new executive judicial rapprochement will bear fruit, because our judges have long suffered.
The judges' salaries are so poor. And I said it to your lordship, that good chambers in this country pay more than what justices of the Supreme Court earn to new intakes in their chambers. And I have said it over and over, and I told Mr. President that the take-home pay of a justice of the Supreme Court is 250,000 naira a month. Yet you expect something good. I'm not saying they are not doing anything good. They are doing much. But what do you expect from them under these very, very disturbing circumstances? Very brutal, very brutish, very harrowing.
The governor of Lagos, Babajide Sanwo-Olu, also encouraged the body of senior advocates to continue to ensure the rule of law in the country.
You are all professionals. You are all outstanding Nigerians, outstanding individuals of no small mate in our country. And I want to admonish you as well and say to you that the ordinary citizens too are watching. We believe that indeed the common man has no place to go other than to believe in your profession and in expectation that is anyhow you take us, that will land. Even as a governor, there are things that I cannot do. There are decisions that I cannot take alone. There are pronouncements that I cannot make just because the law does not allow me, and my advisors have said you cannot do that.
When the honoree took the podium, he addressed some of the issues earlier raised and gave a solemn promise to leave behind a success trail that the next generation can emulate.
As for what happened in the Supreme Court a couple of months ago, which had kept recurring, there was no petition and there was no letter at all written to or against anybody. There were 15 justices of the Supreme Court then, and if 14 behind the then Chief Justice came up with a write-up and personally presented this to the number one, that cannot be said to be a petition. It was an internal memo. It was a memo prepared by justices, taken and presented to our brother, the Chief Justice. And we reminded His Lordship that this paper contained what we had either individually or in groups or collectively come to discuss with His Lordship. This was not written or typed by any secretary of the Supreme Court. One of us, a justice of Supreme Court, got it like dictation into the computer, and no justice had a copy. It was read, written, corrected, and printed straight away, and we took it, described as memo to the Honorable the Chief Justice of Nigeria. And that's why we say how it got to the press. You might want to say only God knows. But we later discovered from the tone of the response from the office of the then Chief Justice, when the justices of the Supreme Court were described as dancers nakedly at the market square, we discovered that no, somebody must have meant war, and there was no need to fight. We were one, and we remain one. And since then, we had moved forward. The 13 justices left in the court, we had agreed with this Chief Justice out of it to be in 4 committees to run the affairs of the Supreme Court together. Each of the justices behind me, number 2, number 3, number 4, number 5, we've all agreed to head 4 committees and 2 justices supporting, as you know, finance and accounts, litigation and health services, administration, and welfare of justices and staff. So, justices are now running the affairs of the Supreme Court by themselves. It is our court. The administration and the staff are to support and assist justices, not to take over the running or the affairs of the court. So each of the justices of the Supreme Court now has a role to play in the administration of the court. I immediately summoned the chief registrar and told her, you might want to say, and warned her, that this is our court. She was worried that His Lordship started asking for all accounts. I said, give him all accounts, except you have something to hide. I want to assure you all, please, that the justices of Supreme Court are one, and we shall remain one. Our trouble, learned Bosan, is that out of 21 that the Constitution says must run the court, only 12 of us are there now. 12 are functional. One of us is seriously indisposed for a couple of months now. An attempt to bring in more justices, there's no fund, there's no money. If there's no money to buy mobility, if our brothers who joined us in the Supreme Court 2 years ago, some are yet to be accommodated. Some are yet to be given the full complements of their cars. How do you go ahead and bring in 6 more justices and you now start to grumble. We should now be grumbling to say the government has failed. They said they don't have money. So please, you pardon us, and we need your support. Bosan particularly, we need you. You always think it's the Bosan and the bar that need this court. No, we need the Bosan too. And please, there is no bench without the bar. There is no bench without the bar. Without the cooperation of the bar, the bench will fail. I believe you have assured us that we shall not fail you. It is only when you cooperate with us, you support us, that we shall move together and to great success.
Away from that event, we move on to another event that also attracted a rich crowd of members of the bench and the bar. Not less than 30 judges cutting across the appellate, federal and state courts attended this event, which was to launch a book with the title, The Compass, a Compendium of Civil Rules and Regulations. We have highlights from that event in this next report.
Gathered here are judges of the appellate courts, the federal and state high courts, senior advocates, members of the outer bar, and many others. They are all here for the launch of the book, The Compass, a compendium of civil rules and regulations. The book highlights some of the major debates and controversies in the rules of procedure of civil cases. It exposes the issues of technicality in the pursuit of substantial justice and the differences created in the rules of interpretation. The chairman of the occasion, retired Supreme Court Judge Justice Ejembi Eko, shared some of the important civil procedure rules debate that the book spotlights.
The controversy is still on. You will find that in some of the judgments coming from the superior courts, especially the appellate courts, some towing the liberal view that a defective writ is still procedural, and any procedure, rules of procedure can be waived. And then taking the line of waiver, we will say, okay, since you have waived your right, you cannot be hard to complain later. And that raising the issue of non-compliance or defect of the writ of summons is just an arcane technicality that the courts are now walking away from. So this debate is still on. You will find it in the book.
Vice-Chancellor of the University of Ilorin, Professor Wahab Egbewale, who gave a comprehensive review of the book and its authors, had this to say.
The compendium by these erudite scholars and practitioners is a 943-page document, excluding all the preliminary pages. The content is an all-inclusive iteration and new knowledge of civil procedure rules of the High Courts of Nigeria.
Other speakers were quick to recommend the book. They are hopeful that the book will deepen the jurisprudence of legal and institutional procedures in the country. One of the authors also used the opportunity to further highlight the reason for the revised edition of the book.
The Compass, a compendium of civil procedure rule in Nigeria, is the latest publication from the stable on high court civil procedure rules all over Nigeria. The precursor to this was the Book 2 2012, which ran to third edition and blazed the trail in expounding on the innovative and revolutionary rules of the civil procedure originated by Lagos State Judiciary in 2004. The Compass has been adjudged by review analysts as the most authoritative work on civil procedure in the country, using the lens of Lagos, Abuja, and Federal High Court rules, with cross-referencing traversing boundaries of other states of the Federation and the National Industrial Court. Uniform civil procedure rule, necessary as it is virtually emerging. It must be an evolutionary process, as we are currently witnessing, since the court rules of procedure must not be legislated legislated upon. Development.
The book, The Compass, a compendium of civil rules and regulations, has been recommended for judges, legal practitioners, the legislature, researchers, scholars, policymakers, and educational institutions, such as colleges of law and research centers generally.
Welcome back. Charged with the goal of eradicating economic and financial crimes through prevention, enforcement, and coordination, the Economic and Financial Crimes Commission held a one-day workshop for journalists on Tuesday, the 25th of October, 2022. It had the theme, Financial Crimes Reporting. Here's the report.
The workshop was attended by a selected group of journalists from the print and broadcast media who have worked closely with the anti-graft agency in the recent past. The aim is to deepen their understanding of the newly enacted Money Laundering Prevention and Prohibition Act 2022, which will support the Economic and Financial Crimes Commission in its sustained fight against terrorism financing and corruption in Nigeria. It was also an opportunity to brainstorm on ideas as well as to identify problems and develop solutions to the limitations of an effective media role in combating corruption. The Lagos Zonal Commander of EFCC, Ahmed Gali, standing in for the Executive Chairman of the EFCC, Abdulrasheed Bawa, commended the efforts of the media and charged them to brace up for more work ahead.
The EFCC would like to see greater collaboration and information sharing between the media and the Commission. We can only ask for more support, while also urging you to do your work with utmost sense of responsibility. Gentlemen of the press, let me use this opportunity to restate the Commission's unwavering commitment to fighting all forms of economic crimes in Nigeria.
The executive chairman of the EFCC, Abdulrasheed Bawa, who was subsequently able to join the meeting virtually, re-emphasized the importance of the press in sensitizing the public about the new Money Laundering Act 2022.
Special Control Unit Against Money Laundering, which is now domiciled in the EFCC. The work of the Special Control Unit Against Money Laundering is to ensure compliance with the provisions of money laundering as it relates to non-designated professions and businesses in our country. By that, summarily, we are talking about entities like the car dealers in precious stones, tax consultants, accountants, legal practitioners, those in the construction industry, real estate agents, etc., etc. They are obliged by that to register with school and to be making reports to school. Now, the whole idea of it and the rationale behind the fact that in our country, like in other countries around the world, these entities tend to be seen as the gatekeepers of money laundering. People use their avenues to launder the proceeds of crime. So if we are monitoring them beforehand, we are going to be proactive, by knowing who is using them, in terms of laundering the proceeds of crime.
Cybercrime is on the increase, and an investigator with the Commission, Mustafa Hafiz, gave a slide presentation on the trends and challenges of cybercrime enforcement in Nigeria. The Deputy Director, Legal and Prosecution of the EFCC, Bolahon Latono, who delivered another presentation, spoke exclusively about the challenges of prosecuting economic and financial crimes in Nigeria. The third speaker, an assistant commandant with the EFCC-1, Dele Oyawale, dwelt on the best practices in financial crimes reporting and highlighted three major mistakes journalists make when reporting.
Fundamentally, we want to talk about the unreported crimes, the underreported crimes, and the unfollowed crimes. Financial journalists are expected to be several miles ahead of the law enforcement agency in their reporting, in their analysis, in their investigation, in their in-depth presentation of what is happening in the financial space.
The workshop was indeed an eye-opener into some of the issues that journalists overlook and should pay more attention to going forward.
And just before we go, let's do a quick recap of some of the top legal stories we're tracking at the courts.
We begin with the report that the Economic and Financial Crimes Commission, EFCC, has rearranged the suspended Accountant General of the Federation, Ahmed Idris, and 3 others over alleged 109.5 billion naira fraud. The 3 other defendants are Olusegun Akindele, Mohammed Usman, and Gezawa Commodity Market and Exchange Limited. They were all rearranged before an FCC High Court sitting in Maitama, Abuja. When the charge was read to them, they all pleaded not guilty, and following their not guilty plea, their lawyers asked the court to allow the defendants continue to enjoy the earlier bail granted them by the court. Justice Yusuf Halilu granted the request but directed that the defendants submit their passports to the court's registrar. He subsequently adjourned the case to November the 23rd for hearing. Staying in Abuja, the Federal High Court has ordered the final forfeiture of 2 properties in the Federal Capital Territory and 2 luxury cars belonging to a former Minister of Petroleum Resources, Mrs. Dezani Alison Madueke. Justice Mobalaji Olajuwon gave the order forfeiting the assets to the federal government of Nigeria while ruling on the application by the EFCC seeking the final forfeiture of the assets. The FCC said the assets were proceeds of unlawful activities. In another suit, the leader of the indigenous people of Biafra, Nnamdi Kanu, has commenced a fundamental right action before the Federal High Court, Abuja, demanding his release from the facility of the Department of State Services, DSS, and the payment of a sum of 100 billion naira as reparation for the gross violation of his rights to liberty and dignity. This follows the judgment of a court of appeal which had struck out the retained 7-count charge and discharged him. Meanwhile, at the Federal High Court, Umuahia, Justice Evelyn Ayadike has ordered the federal government to restore Nnamdi Kanu to his status quo before June the 19th, 2021. The judge was ruling on another fundamental human rights and extraordinary rendition suit filed by the IPOB leader. The court also ordered the government to pay Kanu 500 million naira as damages. In Enugu, the Federal High Court has adjourned the suit seeking to declare vacant the Enugu West senatorial seat being occupied by Senator Ike Ekweremadu. Justice Umar Garba held that the motion filed by the applicant, Ogochukwu Onyema, could not be taken in the absence of 7 out of 8 parties in the suit. The matter has been adjourned to November the 9th. And in what appears to be a repeat of the plight of the Rivers State chapter of the All Progressives Congress in 2019, the Federal High Court sitting in Port Harcourt has nullified all the primary elections conducted by the party in Rivers State. The court in its ruling held that the exclusion of some members of the party as delegates to the primaries invalidates the whole exercise.
And that's our program for this week. Don't forget that you can find this episode of the program and past episodes on our YouTube channel. I am Shola Sheyele. Thank you for watching and see you next week.